Hi everyone, welcome back to my YouTube channel. So today we'll be talking about discrimination in the employment setting. I hope you enjoy this presentation. If you're new to my channel, Happy New Year to you. If you're a current subscriber, Happy New Year as well. Join me along. So a person can be discriminated against on the grounds of the person's race, religion, national origin, sex, or color. So these are referred to as the protected characteristics. So in the employment setting, one has to be very careful, especially the supervisors, the employers, you have to be very careful so as not to do something that would make a person feel he or she has been discriminated against. And in such a situation, a claim may be brought by the EEOC or the individual as regarded. In proceeding with an employment discrimination case, a person can adopt either of the following theories. There's the disparate treatment theory and the disparate impact theory. So the main difference between these two theories is that there has to be intent for somebody to proceed by using the disparate treatment theory. So an example here will help. For example, let's say Abby Susan, who works in a particular organization, feels she's been discriminated against because she's female. That's because of her sex or her gender identity. In that kind of a situation, if Susan wants to proceed with this disparate treatment, she has to prove that the employer had intent, that there was an intention to actually discriminate against her. Whereas disparate impact will apply in a case where there's a policy at the workplace and the effect of that policy largely affected the women or those who identify as the female gender at that workplace. So in that kind of a situation, the better way to approach the employment discrimination case is by going through the disparate impacts. So there has to be intent for there to be disparate treatment theory to apply in this situation. It is very important to bear in mind that whichever of the theories one is applying, one can either come by using direct evidence or circumstantial evidence. So direct evidence is where the person who is claiming to have been discriminated against has something, has a smoking gun, something to show that the employer actually made some comments or actually did something that shows that he or she has been discriminated against. For instance, if there was an email written to the effect that, oh, all women are not wanted at this workplace, for that reason we have to kick them away, or people who are of so age, people who are of 40 years and above are no longer needed in this organization. In that kind of a situation, there is a direct evidence to substantiate that claim, stating that a person has been discriminated against either on the grounds of religion, sex, age, national origin, color, or as the case may be. But in the case of circumstantial evidence, the McDonnell-Douglas test is what will apply in that situation. So there are some particular things that a plaintiff must show in order to establish a prima facie case. The first one is that the person must show that he or she or they belong to a protected class or minority. So for instance, for a person to bring a case under this theory, you have to show that if you're using circumstantial evidence, you have to show that one, you're a person that is of a particular age. For instance, if you're bringing age discrimination case, you have to show that you're above 40. That's an example. So a person who is 60-year-old can say, yes, because of my age, I have been discriminated against. I belong to this protected class of age. Another example is a person who is a Muslim or a person who has too much beard and identifies with the Islam religion. So in that kind of a situation, the person establishes that he or she belongs to this protected class. Another example would be cocaine, for instance, a person who identifies as gay or queer. So in that situation, the person says that because of his identity or the sexual orientation, they feel they have been discriminated against. The second thing the plaintiff must prove is that the plaintiff is qualified for the job. So it's one thing to belong to a protected class, it's another thing to have the necessary or the required qualifications for that job. So you must be qualified. You cannot just claim you've been discriminated against, whereas you don't meet the requirements for that job. In that situation, an employer could argue that they didn't employ this person because the person did not meet the requirements for the job. The third thing that has to be proven is the fact that the person was subjected to an adverse action. So what's an adverse action? Adverse action could be refusal to employ someone. So in a case where a person does not belong to that organization yet, you have not been employed yet, so you were refused employment. Another example would be if you're already a member or you're already part of that organization, you've been employed by the employer, but you feel that maybe you have been refused a promotion or you were demoted or you were transferred to another department and you feel that that was because of your protected characteristic, then that could fall under the class of adverse action. The fourth thing that a plaintiff must prove is the fact that discrimination was the actual reason for that adverse action. So if you say you were not selected for a particular role that you applied for, you have to show as a plaintiff that it was because of that your protected characteristic that you were refused that job. So I hope these examples have helped in understanding better. It's very necessary to note that after a plaintiff has established the prima facie case, so we have what we call the burden shifting theory. So the burden now shifts to the defendant. So the defendant in this case is mostly the employer. So the defendant has to prove that the reason for rejecting the plaintiff, let's assume it was a case where a person applied for a role and the person wasn't offered the employment. So the reason for rejecting this plaintiff or this prospective employee was because the person did not have the requirements for the job. So the defendant has to show that there were some non-discriminatory elements tied to the plaintiff's rejection. Once the defendant is able to prove this, the burden now shifts back to the plaintiff. And in that instance, the plaintiff will have to prove that the defendant's reason is merely pretextual. So the plaintiff has to show that the reason the defendant is saying they refuse to accept the plaintiff for that role is mere pretext. In the last two slides, I have discussed the circumstantial evidence. Now it's time to discuss direct evidence. So when there is direct evidence, that means the plaintiff is saying that the person has cogent evidence. You have something to show, something real, not just based on circumstances or based on what you think. This time around, you have something to catch, something that has caught the employer red-handed to show that really you were discriminated against. So in a situation where a plaintiff has direct evidence, there is no room for doubt. Most times, cases where direct evidence is being used, comments are actually being referred to. So the comments could have been made via messages, text messages, via emails, or written comments on paper. So once you can show that there is something solid against the employer, something to show that the employer actually made those statements or made those remarks to you, then direct evidence is applicable. There's a four-part test for direct evidence. The first one is that the comments must be related to a protected class. So let's assume in an employment organization, a particular comment was made to, let's use John Solo as an example. So John Solo is a Christian, for instance, and he's 50 years old. So a particular comment was made by the supervisor, for instance, one day, and the supervisor says something like, "Oh, we don't want all these slow and sluggish snails in our workplace. These people are already becoming too old and we no longer need them here." So such a comment is related to a protected class. It's referring to the person's age. Or another example would be where we have somebody called Mohammed Hussein, for instance. Mohammed Hussein, maybe he has so much beard, he's a Muslim. So they are trying to say that, okay, because this person is Muslim, he must be a terrorist. So they are linking him to Osama bin Laden. So in that kind of a situation, this person is being attacked on the basis of a protected class, his religion and his national origin. The next thing that must be present for there to be direct evidence is that the action, the comment must be proximate in time to the adverse action. So this comment that was made by the employer or by the supervisor was so close in time to the adverse action. So for instance, after the comments were made about Mohammed Hussein, he was being terminated or he was refused employment if he was just applying for that job. So that closeness in time between when the comments were made and when the adverse action was taken must be present. The third thing that has to be present for there to be direct evidence is the fact that the person making the comment must have the authority. So a supervisor will usually suffice in this case, somebody who has the authority to hire or fire. The HR manager, for instance, somebody who has the authority to hire or fire makes this decision, then it's really cogent in that situation. And the fourth thing that must be present is that the comment that was made must be related to the adverse action. So this is similar to the second point and the first point. So all of these, they work hand in hand to ensure that the direct evidence can be used. Otherwise, if any of these tests, if any of these four-part tests is failed to be met, then the comments will be treated as merely stray remarks. But in a situation where the comments are treated as mere stray remarks, all hope is not lost for the plaintiff. The plaintiff may proceed with the McDonnell-Douglas test, and this has to do with circumstantial evidence. There are instances where a plaintiff may have made a prima facie case to show that discrimination was done against the plaintiff, and the employer brings a defense stating that the employer would have actually taken that adverse action even if there was no discriminatory intent. That kind of a situation is referred to as mixed motive case, whereas the employer is trying to say that regardless of the discriminatory claim that has been brought against the employer would still have done what he did. So an example will suffice in this case. Let's assume Sarah Solo applied for a particular job, and Sarah claims that she wasn't given the employment on the basis of her religion, for instance. The employer may actually make a case by stating that irrespective of the discriminatory intent, the employer wouldn't have hired Sarah in this case because Sarah did not meet the minimum requirements for the job role. So in that kind of a situation, that's like a mixed motive case, whereas the employer is saying there might be the discriminatory intent on one hand, but there was actually a legitimate reason for not hiring this person. So there's a mixture of the motives here in this case. Direct evidence is not required to establish a mixed motive case. And the importance of mixed motive cases for the employer is the fact that it limits the damages the plaintiff can get. So the plaintiff will only be able to apply for declaratory reliefs or injunctive reliefs, attorney's fees, and costs may be sought in addition. That's all the plaintiff can get. I hope you found this video really useful. Please like my video, share, continue to subscribe. Thank you.